wabarakatuh. My name is Najiha Binti Mohamad Thanawi. My metric number is 254008. So today our group will be present about the topic of Hibah. So without the further delay, so I will be explain first about the definition of Hibah. So the word of Hibah is come from the Arabic word al-Hibah, which means giving a person that's when he is still alive to others without reward or free gift, either the property or no property. So it is literally means passing or blowing. In technically, it is Hibah is a voluntary contract that results in the uncompensated ownership transfer between the living individuals. Hibah also can be defined as a transfer of legal and beneficial ownership of the assets from the donor to the beneficiary on a volunteer basis. So under the Hibah, the proportion of the distribution of heirs and the non-heirs can be determined by the donor. Okay, second one is the evidence or the verse that we found from the Al-Quran and also the Hadith. So from the Al-Quran, we found that from the surah Al-Baqarah ayat 177 yang membawa maksud dan memberikan harta yang dicintainya kepada kerabatnya, anak-anak yatim, orang-orang miskin, musafir yang memerlukan pertolongan dan orang-orang yang meminta-minta dan memerdekakan hamba sahaya. Okay, the second one is from the surah An-Nisa ayat 4 yang membawa maksud, kemudian jika mereka menyerahkan kamu sebahagian daripada mas kahwin dengan senang hati, makanlah atau ambillah pemberian itu sebagai makanan yang lagi baik akibatnya. Next, from the hadith reported from Anas, which made was brought to the messenger of Allah, and it was said that was given to the Barirah as a charity, and Rasulullah sallallahu alaihi wasallam said that for her it is a charity and for us it is a gift. The second one is from the narrated from by Aisyah, the Prophet sallallahu alaihi wasallam used to accept gifts and exchange gift so that you may love one and another. Okay, next is the pillars of Hibah. So the rukun or rules of or pillars of Hibah can be divided into 4, which is a donor, or we call it as al-wahib, al-mawhub lah, the doni, al-mawhub, the gift, and the fourth one is the sirah, ijab and kabul. So all the pillars are the subject to certain conditions to validate the entire Hibah contract. If there is not complete one and another, the Hibah will be invalid. So the first one, al-wahib or donor. Al-wahib or the donor is a person that gives a Hibah or Hibah provider. The person also must be sound mind, has rich puberty and rushd or wise in managing property. The second one is al-mawhub lahu, the doni. The doni means a person who received the Hibah. The third one is al-mawhub, which means the gift. The legal requirement for the Hibah is the donor must be legal owner of the property, al-mawhub, and there is no barrier to the ownership and the management. The last one is sirah, ijab and qabul, a pronounced man or deed that carries the meaning of the grant and receipt of the Hibah. It is a subject to the following condition, where the first one is there is no connection and similarity between the ijab and qabul. The second one is no specific condition, and the last one is not required for a certain period of time. In this case of Hibah, umrah and rukbah, it is a lawful, but the terms of the period stipulated are void and inapplicable. Okay, next is the condition of the Hibah. So basically, under the condition of Hibah, to make sure the contract of Hibah is valid, so the Muslim scholars have agreed that we need to meet the certain requirements which is the requirements that we need to complete is the condition of the donor. So under the condition of the donors must be eligible to give his property voluntarily to another. The second one is the donor must be a legal owner to the object. The donor also must be mukallaf, legal age, and must be matured or rushd. The second one is the condition of the donee, the recipient. The donee is any man with or without legal capacity. If the donee has the legal capacity, he or she can be receive the club gift by him or himself. If he or she is not eligible recipients, the recipient or club has been done by his legal guardian. So the last one is the condition of the object. So every object which is legally tradable from the Sharia perspective is considered legal to be given as a gift. The object must be in existence in the time of the contract. The object also must be a valuable property, and the last one is the donor must be the owner of the object. So I think that's all from me. So I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. So I am Nura Aini Binti Mustafa Kamaludin. We'll continue on presenting on practice of Hibah in Malaysia. So Hibah is well accepted in Malaysia as one of the tools for estate planning. This is because Hibah gives a solution for providing wealth to non-heirs or any other personal aims in relatively lower cost than the other estate planning tools. In a broader context, Hibah has also been used as financial instrument in the Islamic financial institutions, product and services. Based on that, Malaysian legal system might be affected in two different situations, either under the jurisdiction of states for the classical Hibah or under the federal government for the commercial Hibah. For the legal process of Hibah, Hibah can be executed in the form of direct Hibah or Hibah trust. Direct Hibah involves a less complex way of transferring ownership from the donor to the donee. And once the direct Hibah has been executed, the ownership is transferred completely and the donor has no right over the asset. For example, Aminah giving bracelet for Alia's birthday. So Aminah will no longer have right on the over the bracelet once it has been given to Alia. Okay. On the other hand is Hibah trust. Hibah trust is a combination of Hibah and trust features. In general, it is a gift from the donor to the beneficiaries during his lifetime, which the assets will be held by an appointed trustee for a certain period of time and can only be transferred in the trust deed. Although asset has been transferred to the beneficiaries, the donor can still enjoy the benefits from the asset upon receiving consent, which has been written in a separate agreement from the beneficiaries. For example, is the product of Hibah Amanah from Amanah Raya Berhad or Pre-Hibah from As-Salihin Trustee Berhad. Okay, so this is the Hibah trust model that has been used by numbers of Islamic estate planning companies in Malaysia. So firstly, the donor will express his willingness to transfer the Hibah asset without any consideration and accepted by the named beneficiaries. So ijab and qabul has been performed in the first step. The second one, a trustee will be appointed by the donor to manage and administer the Hibah assets during the donor's lifetime. The third step is a trust deed will be drafted that outlines the term and agreement between the interested parties and also their duties and responsibilities. Besides, conditions such as Umrah and Rukbah will be included in the trust deed. This includes the beneficiary's consent to allow the donor to use the Hibah asset during his lifetime. And the next step, during the donor's lifetime, the appointed trustee will manage the hibah asset as per agreed in the trust deed. And after the donor's death, or after a specified period of time in the trust deed, the trustee will distribute the hibah to the named beneficiaries in accordance to the trust deed, and the ownership of the asset is fully transferred to the beneficiaries. Okay, so in Malaysia, there is no allocated provision being enacted on hibah. To date, Malaysia only applied the provisions of the jurisdiction of Sharia Court as set in Item 1, List 2, the 9th Schedule of Federal Constitution. The provision states the term of gift, which indicates the hibah is a part of affairs places under the Islamic religious administration of each state and directly involve the jurisdiction of the Sharia Court. And due to that, different states using different terms in reference to hibah. The terms of alang has been applied in Selangor, Melaka, Pulau Pinang, Johor, Perak, Kedah, Terengganu, Sabah and Sarawak in reference to hibah, while Negeri Sembilan use the term of hibah, and the terms of gift has been used in Pahang and Perlis, while Kelantan use the terms of alang hayat to refer in reference to hibah. Most of the hibah cases litigated in the Sharia courts involve the hibah confirmation, hibah disputes value or level, and hibah withdrawal case. And concerning to the hibah withdrawal case, there is one case of Muhammad Mohd bin Haji Abdullah versus Fadilah binti Haji Abdullah and others in 2006, where in this case, the appellant appealed against the decision of the Sharia High Court judge who rejected the appellant's claim confirming the withdrawal of his mother's grant with allegation that the hibah was not valid because al-qabad did not exist. These cases prove that hibah can be challenged in the Sharia court if dispute occur from the legal aspects according to the law of Sharia, or any of the hearers who disagree with the contents of the hibah after the demise of the donor. Okay, so Amanah Raya Berhad is one of the leading trustee firm wholly owned by Malaysian government, which offers the service of hibah, and they have two services of hibah, which named Hibah Amanah Raya and Deklarasi Hibah. So Hibah Amanah Raya is a contract or grant of belonging of donor to the donee, and Amanah Raya is appointed as the trustee of hibah property for a certain period based on the hibah deed and the trust deed. And Deklarasi Hibah is a written statement explaining the position of the property that has been donated to the donee during the life of the donor of hibah. A grantor will be appointed as the principal trustee of the endowed asset, and Amanah Raya will be appointed as a replacement trustee on behalf of the trustee upon the death of the grantor. So this is the documents needed for Hibah Amanah Raya. So the first one is Hibah Amanah Raya application form, and the copy of identity card of the settlor, the beneficiary, wali mal, guardian and the witness. And Hibah Amanah Raya can be involve the movable property and the immovable property. So the movable property, only cash and banker's check are accepted to be the hibah property, and it needs of the fees. And for the immovable property, the additional documents needed are the copy of land grant, the fire takaful policy. Other than that, it needs of original receipts of property assessment or the current assessment tax, and original receipts of the quit rent. The deposit, payment for the expenses incurred, and the stamp duty. And the documents needed by the Deklarasi Hibah is the Deklarasi Hibah application form, copy of identity of the donor and the donee, the fees, copy of land grant, takaful policy, and original receipts of property assessment or the current assessment tax. In the Deklarasi Hibah, only immovable property can be the Hibah property to be transferred to the donee. Okay, next, this is the fees and charge that involve for immovable property under the Amanah Raya Berhad. So the fees is acceptance fee, income fee, execution fee, legal fee for trust deed, legal fee for the transfer for land, government service tax, and others. And for the immovable property, it needs of acceptance fee, income fee, execution fee, legal fee for trust deed, and government service tax. Okay, next is the Salihin Trustee Berhad is another is a private companies that offer a service of hibah. So Salihin Trustee Berhad is a trust company registered under the Companies Act 2016 and under the Trust Companies Act 1949. It was created to fulfill the ordinary Muslim's crying need to conserve, protect, and distribute his ordinary Muslim, preserve, protect, and distribute his hard-earned properties strictly based on the principle of Sharia. So the product offered by the Salihin Trustee Berhad is named Pre-Hibah. So Pre-Hibah is a declaration of hibah by the owner of a specific asset, stating that he gives the asset to the beneficiary, and a written document wherein the terms and conditions on which the settlor is holding the assets are set up. So for the documents needed for the pre-hibah of Salihin Trustee Berhad is hibah application form, the copy of identity card of the protector or the guardian, and the instruction form duty signed by the customer. Okay, so the documents needed for pre-hibah of Salihin involve except three different assets, which are shares in the private limited company, landed property, and the investment account. So the documents needed for pre-hibah under the shares in private limited company is the forms 24 and forms 49, and the forms 8 or forms 9 related to the company registration. And document additional document needed for the landed property is the copy of the title deed, the address of the property if applicable. And lastly is under the investment account, the document needed is the account number of the investment account and the investment company bank. As for the fees and charge involved in Salihin Trustee Berhad, it has been divided into three parts, which are the pre-hibah setup fee, the third party cost, and the trust administration fee. So for the pre-hibah setup fee is calculated based on the number of clauses of the hibah. Next is the third party cost. It involves the registration of the power of attorney and the revocation. And lastly is the trust administration fee, which involve the movable assets, immovable assets, income bearing, and immovable assets not income bearing. And lastly is the holding of company shares. So that is all about practice of hibah in Malaysia. Thank you.
Assalamualaikum. My name is Farhana Binti Zulkifli. My number matric 255380. Now I will present on the part of new practice of Hibah. Nowadays, the practice of Hibah in wealth management is very popular in our society. Hibah be a solution to deliver wealth to non-health apart from the wasi'ah and fa'id system. Hibah is precisely defined as a contract to transfer ownership of wealth voluntarily without any compensation and given to someone else during the lifetime of the donor. The owner of the wealth has the right to decide how much amount or portion of the wealth to be distributed to the others. Granting property through hibah is encouraged by Islam as to promote the concept of maqasid syariah in terms of protection of wealth. Hibah is important as Islamic estate planning to economic development of Muslim community. This because the circulation of wealth can make sure that the benefit of wealth is continually enjoyed by the society without left-frozen and outstanding. The stress of hibah is important to boost economy and to avoid disputation over inheritance that can lead to the frozen estate problem. In Islam, there are two ways of hibah practice that be permitted. First is hibah as a waste management, and second is hibah as a supporting of financial instrument for Islamic banking product and service. For the first one, as a waste management is a classical hibah practice by the Muslim as a tool to distribute their wealth and asset after death. This classical hibah is not governed by any specific standard to be referred. For the second type of hibah is as a supporting financial instrument. The hibah is a modern concept of hibah. The application of hibah has also been practiced as a type of supporting financial instrument to main Islamic financial institution product and service. And this type is considered as a commercial hibah or called as a commercial hibah. The commercial hibah is attached to other type of Islamic financial institution main product and service, such as a contract of buying and selling, al-bay, contract of lease, al-ijara, contract of kafala, awanu, and also included the takaful contract. Hibah instrument also be used in takaful product, and there are two types or two ways of takaful hibah. First is direct hibah and second is conditional hibah. For the direct hibah is the takaful company we offer takaful product to the participant that the benefit will be surrendered to the hibah recipient upon the maturity date of the certificate. Under this concept, beneficiary may be the child of the participant or the participant of the takaful itself. The hibah will cover such as education plan, medical plan or saving plan on behalf of the beneficiary and other type of the plan that offered by the takaful company. Then we move to the second way of takaful hibah, which is conditional hibah. Conditional hibah is made in respect of nomination of the takaful recipient by the participant during his lifetime. The takaful participant will nominate who will the actual beneficiary and who will receive the benefit as the executor of the asset. This hibah is enforced subject to occurrence of the event occur such as death of the participant. This conditional of hibah is taking the conditional element in hibah wukbah, which is they also have hibah amanah or hibah trust in hibah as a financial instrument. This hibah is practiced on Sharia compliant trust product and service. This is involved in the trust contract offered by the authorized trustee company, such as in Malaysia we have Pemodalan Nasional Berhad (PNB), Tabungan Haji TH and Amanah Raya Berhad, and also have a few bank that join collaboration with the trustee company and offering the Hibah Amanah service such as Hibah Amanah Raya, which is from the collaboration of Bank Islam Malaysia Berhad and the Amanah Raya Berhad. This concept is formed to protect minor recipient or recipient that mentally incapable by law and they may not be able to manage the wealth by itself. The trust normally be given to nearest family members such as sibling, father or mother, that will act as a trustee to manage the wealth until the child is at the age of majority. The Hibah trust application and concept have been modified time by time so that the concept will be acceptable by the time. The new concept of Hibah trust, the owner will appoint any trustee to manage the wealth. The main difference between the direct Hibah of the Takaful and the Hibah trust is the direct Hibah involves direct transfer of the ownership of wealth to the donee or the recipient, and the Hibah trust is wealth already been transferred to the beneficiary, but the donor still can enjoy the benefit or the asset. Okay, that's all for me, and thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nursazlin binti Razali and my matric number is 258950. Today I will explain about the fatwa of Hibah and expert thought of Hibah. Ruling and implementation of Hibah. Hibah is a practice that is favorable or sunat in Islam. Hibah practice is based on the primary sources which is Al-Quran and Al-Sunnah. Also based on the secondary sources which is Ijma or consensus. Firman Allah Subhanahu wa Ta'ala in Surah An-Nisa verse 4 and Surah Al-Baqarah verse 177. The meaning of the Surah Al-Baqarah verse 177 is, and give wealth in spite of love for it to relative, orphan, the needy, the traveller, those who ask for help, and for freeing slave. Surah An-Nisa verse 4 means, but if they give up willingly to you anything of it, then take it in satisfaction and ease. This surah recommended or preferred to a husband give a hibah to his wife. There are also hadiths from Rasulullah sallallahu alaihi wasallam narrated by Imam Malik, tahaddu tahabbu, that derive the meaning of giving each other gift and you will love each other. Acceptance of goods in hibah, or we call as al-qab. I give a table, which is the first one is Imam Hanbali and Imam Maliki. The another one is Abu Hanifa and Imam Shafi'i. Imam Hanbali and Imam Shafi'i said that the receipt of goods is not a condition in hibah. It is enough with the akad, or we call as a approval, ijab and kabul. However, Abu Hanifa and Imam Shafi'i said that the receipt of goods is considered as one of the condition in hibah. Imam Hanbali and Imam Maliki give a point of view that if there is a death of either the hibah provider or hibah receiver before the delivery of goods, the hibah is considered as valid. But for Abu Hanifa and Imam Shafi'i, if there is a death of either the hibah provider or hibah receiver before the delivery of goods, the hibah is considered as void. In addition, Imam Shafi'i defined that al-qab is an essential condition for hibah. So the hibah contract does not complete just only with the akad, unless after the acceptance of the goods. Shafi'i also gave his thought that the hibah contract is not a binding contract if al-qab does not function properly. This is the three conditions to ensure that the hibah contract is the binding contract. The first one is the permission and consent from the hibah provider must be clear and understandable. which means the hibah provider must declare clearly about his or her wish to give a hibah so that it can avoid misunderstand in the future. The second one is the hibah recipient already reached the puberty and sound of mind. In case of the hibah recipient is children, or the person who is insane, so the legal heirs of the family or trustee can receive the property of hibah on behalf of this recipient. So the third is there are no other properties that mix with the hibah property. Hibah withdrawal or revocation. So generally, the hibah contract is considered complete when the property had been transferred or accepted by the hibah recipient by fulfilling the terms and conditions. However, there are some disagreement between the jurists regarding the withdrawal of hibah after complete the al-qab. That means, is it hibah provider can withdraw back the property that had been given to the recipient? So Hanafi gave his point that the hibah provider can withdraw the hibah, but it's involved in unfavorable status, which is makruh. Shafi'i and some experts from Maliki said that hibah withdrawal can happen with akad, but when the hibah property had been delivered, so the hibah cannot be withdrawn back. Imam Ahmad and Zahiri, both of them are strictly prohibited the hibah provider to withdraw back the hibah that already been given to the hibah recipient unless the hibah had been made by the father to his children, and it is based on the Prophet SAW saying that the means is one who gets back his gift is like a dog which vomits and then swallows that vomit. So this hadith had been narrated by Al-Bukhari and Muslim. Okay, this is the table that I make to make it easier to understand about the different views among experts that that I already explained just now. And for Hanafi, it said that if the hibah provider take back the hibah property, it is a makruh. Shafi'i and some experts from Maliki said that the hibah that already given to the recipient cannot be withdrawn back unless it is made by the legal relationship in family, like his father to his children, and does not related to other person or other people. For Imam Ahmad and Zahiri, they strictly prohibited that the hibah provider cannot withdraw back the hibah property unless the hibah had been made by the father to his children and other sources to his children, which is the legal blood relationship in the family. So the hibah property can be withdrawn. Okay, in terms of the cancellation or withdrawal of hibah, the experts agree regarding the cancellation or withdrawal of hibah if both party, which is hibah provider and hibah receiver, are agreed. In Islam also, Islam permits the revocation of hibah if the hibah made by the father to his children, or in simple word, the legal heirs that has the blood relation in the family. It's not related to the other person. For the revocation, the hibah property must be or still in the possession of the person that has a blood relationship. Hibah cannot be withdrawn if the property has gone beyond the jurisdiction, such as had been sold, wakaf, or given to the other person, and the property already been received by the other person. So it cannot be take back the property. Extend to property that can be hibah. So the hibah provider can provide the hibah up to his or her wish, and who is the receiver of the hibah. But the hibah must be distributed equally Because of Hanafi, Maliki and Shafi'i, also Abu Yusuf trust that it is favorable to give hibah equally to children and avoid to give more to one of them because it is unfavorable, which is makruh, although the hibah is valid. According to the Hanbali, fairness in hibah to the children is a compulsory. So the hibah in the form of conditional hibah, which is al-umrah and al-rukbah. Al-Umrah is a gift given during the life of the hibah provider or hibah recipient with the condition that the property will return back after the death of the hibah recipient. That means if the hibah recipient die, the hibah property will be returned to the hibah provider, whereas the hibah property will be returned to the heirs of the hibah provider if the hibah provider dies. Such as, I give this land to you, and if you die, this land will become mine, will be back to mine. And if I die first, then you have to return this land to my heirs. For a rukbah is gift given with a condition made by the hibah provider, and basically it put debts of either the hibah provider or recipient to own the property of hibah. So hibah recipient fully own the hibah property if the hibah provider die. However, if the hibah recipient die before the hibah provider, the hibah property will be returned back to the hibah provider. Is like example, I give you this land to you as a rukbah, and if you die first, then the property will be returned to me, and if I as a hibah provider die, then this land will become yours. Okay, the majority of Islamic scholars give opinion that temporary hibah such as hibah umrah and rukbah are considered valid, but the conditions are considered void. They debate that the contract will be contradict to the demand of the akad if those conditions are applied. They refer to the hadith Rasulullah SAW that said, protect your property and do not grant it away, which is hibah, as umrah for anyone who grants something away as umrah, then it becomes the property of the hibah recipient. Okay, so the view of fuqaha regarding the conditional hibah al-umrah and al-rukbah. So Imam Malik, Imam al-Zuhri, Abu Tur and others as well as Imam Shafi'i, they said that hibah al-umrah is non-compulsory, which is harus, and the conditions are valid if the hibah provider does not specify that the granted property will be owned by the hibah recipient heirs after the death of recipient. So they said it harus. For Imam Abu Hanifah, Imam Malik, they said they allow hibah al-umrah but not hibah rukbah, based on the hadith by the Prophet ﷺ, which is impose hibah al-umrah and reject hibah rukbah. However, for Imam Ahmad, he criticized the Imam Ahmad because this hadith is not validate. So based on this argument, two different reactions from the fuqaha occur, which is hibah al-umrah and rukbah are not required according to the Prophet. Said that do not give hibah either al-umrah or rukbah. However, the other side that allow this kind of hibah argue the hadith which mean hibah al-umrah and hibah al-rukbah is permissible for them. So that's all for the fatwa of hibah and expert thought of hibah. So that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nura, Shahida binti Mohamad, Rozlan. My metric number is 255688. Now I will present about the issues that usually occur in hibah. The first issue is that often raised in hibah is whether the property can be given as a gift or not in the context of it does not fully owned by the grantor. For example, the property that is still under collateral or mortgage, which is not fully owned by the grantor, or property that is still under financing. In fact, nowadays, most of the Muslims need to be in debt in order for them to own a property. For example, to buy a house, they have to borrow from the bank and directly they will be indebted to the bank. If they are not allowed to do hibah on the property which is still under financing, then they will only gain little benefit from hibah because of such constraints. in Islam, there are two methods a property can be owned. The first method is through perfect ownership, and the second method is through imperfect ownership, or also known as milk and nakis. Based on the views of jurists who allow hibah on the property of others, then a property belonging to a giver whose ownership power is imperfect can also be given. Thus, to adhere to the views of Maliki and Hanafi school of thought, which require the granting of hibah to property that is not owned by the giver, with the condition of obtaining the permission of the property owner. It is appropriate to allow hibah property that is still under collateral based on maslahah principle and jurisprudence, which states that a difficulty can lead to convenience. The second issue is the issue arises in hibah umrah and hibah rukbah because of the element of hibah, which is temporary, and hibah, something which is involving one's life. Both of these issues have provoked different reactions among the fuqaha. The school of thought says hibah umrah and hibah rukbah are required based on the hadith of Rasulullah, which means do not give hibah umrah or rukbah. This hadith is narrated by Al-Bukhari and Muslim. The school of thought that require hibah umrah and hibah rukbah were based on the hadith, which means hibah umrah and rukbah are obligatory for them. This hadith is narrated by Al-Bukhari and Muslim. The majority of scholars think that temporary hibah such as hibah umrah and rukbah are valid, but the conditions are void. They argue that if the condition applies and it is contrary to the requirement of the contract of hibah itself. The third issue is there are some overriding Sharia and legal issues which needs to be addressed in hibah amanah. In contrast to the Sharia practice, it is observed that the application and concept of hibah amanah in Malaysia has been modified from its original concept to suit its purpose as a financial instrument. In Malaysia, the practice of hibah amanah is merely a replication of the practice of living trust in conventional counterpart. When hibah amanah is similar to the living trust, therefore it is subjected to the civil law provision. The civil law may have to be referred to in order to understand the concept of hibah amanah itself. The conflict of legal jurisprudence may arise since hibah practice is originally subjected to Islamic law. Besides, in the contemporary practice, the nature of the hibah amanah itself also contribute to the conflict of jurisprudence, jurisdiction, since the hibah asset itself can be in the form of equity and trust. Other issue involved is the legal issues regarding to the application of hibah as a financial instrument in Malaysia, the conflict of jurisdiction between the Sharia court and civil court. Next one is the uncertainty of terms between hibah and gift. Lastly is the hibah also may be possible misuse by the participant to deny the rights and benefits of legal heirs, since the act does not interpret clearly and do not have specific provision of condition of the beneficiary. As the conclusion, hibah is the most competitive and special method of managing wealth during the life of the property owner. This is because of its ability to solve many issues arising that cannot be solved by other wealth management instruments. The privileges of wealth management through hibah make it a method of managing property that began to gain a place in the hearts of Muslims nowadays. Thus, it is not surprising that many property management companies in Malaysia have implemented hibah concept. However, there are also certain issues of hibah which still need to be studied further and need to be resolved. Therefore, the instrument needs to be further strengthened with the support of a clearer and more focused legal framework jurisdiction. That's all from our group presentation. Thank you.